Apoorv sir, shall we start?
Yeah, just give me a second. Just give me a second. Yes, now we can start.
Okay. Good morning. Good afternoon, everyone. I welcome you all to the webinar on the topic Anatomy of IBC Case Laws 11. Today we have with us Apoorv Sarvaria sir as faculty. Let me briefly introduce him. Sir is advocate, IP and qualified independent director. He is currently partner as VGC law firm. He is former judge in District Court, Delhi. As an advocate, he represents insurance companies, banks and financial institutions and other public sector undertakings before the Supreme Court of India, Delhi High Court, NCLAT, NCLT and various arbitral tribunals. He has taken assignments as IRP and RP. He has written many articles and contributes to many law books on different subjects. Recently, one being a commentary on IBC as co-author published by Taxman. He has been resource person for IBBI, ICSI IIP, Delhi Judicial Academy, Indian Law Institute, State Bank Academy and other universities and other law schools. Sir, you may now start the session, please.
Thank you, Anjali. I'm very sorry. I just got a bit held up somewhere. In fact, at NCLT only, I had a matter, so that's why I was just a bit held up. But I'll just share. Today we are dealing with anatomy of cases. So there are 8 cases that we are going to discuss. Relatively, it is going to be not a very long session, but these 8 cases just lay down. They are developing the IBC jurisprudence. Some are Supreme Court cases, some are NCLT cases, and some are NCLT cases. So let me just share a PPT with all of you. And I hope everybody is able to hear me properly.
Yeah, we are able to hear you, sir.
Yes. Thank you. Thanks a lot. So let me just share the PPT first. And a request to all participants, whoever has any doubt can ask at any point of time. You need not wait for a particular slide to get over, because there and then and there we can have clarity of doubts. Our clarity of whatever doubts we have. And of course, in case something is coming in a future slide, then I will let you know that. Just give me a second. Can you see the slide, please?
Yes.
Yes.
Yes, we can.
Okay. So anatomy of IBC case laws. This is one of the other sessions of IBC case laws. If any of the participants have already attended, we are going to discuss cases, recent cases, which are judgment being rendered by the Supreme Court of India or NCLT or NCLT, or maybe even some of the high courts. Also, occasionally they also pass some judgments. So we are going to discuss some of them, and we'll see. These are very different issues, some interesting issues also, which are going to start. So the very first case is Vishal Chelani and others. These are all very recent cases. So this was pronounced on 6th of October 2023 by the Supreme Court of India. And here the main issue was about treatment of just give me a second. Yeah, I'm sorry. So the issue was about treatment of different financial creditors in class. Whether there can be a classification of different financial creditors class in a particular in a same group. So here the appellants, they challenged an order of NCLAT Delhi, which ruled that as a beneficiary of a decree by UP RERA, so Uttar Pradesh RERA authority, the order of RP proposing that they be treated differently from other home buyers allottees does not call for interference. So facts are that appellants before the Supreme Court, they are home buyers. They had opted for allotment in a real estate project of CD, which is corporate debtor, which is Bull and Bull Tech Private Limited. Aggrieved by the delay in the completion of project, appellants approached the UP RERA, which by its orders upheld this entitlement to refund amounts deposited by them. So RERA, some of these applicants had gone to RERA, and they had secured an order from RERA relating to refund of their amounts, whatever they had invested in the company. And just give me a second. So in the meantime, proceedings under IBC were initiated, and in the course of proceedings, a resolution plan. So we are at a final stage of CRP. Resolution plan had come, and it was presented to the adjudicating authority. In that plan, a distinction was made between home buyers who had opted or elected for other remedies, such as before RERA, and having secured orders in their favor, and those who did not do so. So, two classification was made in the resolution plan. One category of home buyers who went to RERA, secured an order of refund, and the other category of home buyers who did not go to RERA, who did not avail any remedy against the corporate debtor, but they only filed claim before the IRP or RP, whatever the case may be. Now, home buyers who did not approach authorities under RERA were given benefit of 50% better terms than that given to those who approached RERA. So, in a way, if you don't go to RERA, you get more benefit. If you approach RERA, then you are at a disadvantage. So, that was the case in this case. This is how the resolution plan was offering benefits to those who did not approach RERA. So, those who are decree holders under RERA, they were having less 50% benefit. The appellants felt aggrieved, and appellants being the persons who all went to RERA, their applications were rejected by NCLT. Then they filed an appeal before the NCLT. That appeal was also rejected. So then consequently, they approached the Supreme Court of India. Now, what are the observations? We are directly dealing with that. We don't need to go to really contentions in this case. It's a short judgment by Supreme Court. It's a 6 or 7 page judgment, but it is laying down something very interesting. First is in para 7 itself, it holds on a plain reading of section 5(8)(f), which is defining financial debt. No distinction is per se made out between different classes of financial creditors for the purposes of drawing a resolution plan. So the court observes that in defining financial debt itself, there is no separate class of financial creditors created for the purpose of drawing a resolution plan. Then thereafter, para 9, it holds that the resolution professional's view appears to be that once an allottee seeks remedies under RERA and opts for return of money in terms of the order made in her favor, it is not open for her to be treated in the class of home buyer. This submission or this view of RP was the court did not find it to be correct. This court is unpersuaded by the submission. It is only home buyers that can approach and seek remedies under RERA, no others. In such circumstances, to treat a particular segment of that class differently for the purposes of another enactment on the ground that one or some of them had elected to take back the deposits, together with such interest as ordered by the competent authority, would be highly inequitable. So I'll just repeat the observation. They're saying to treat a particular segment of that class differently for the purposes of another enactment on the ground that one or some of them had elected to take back the deposits together with such interest as ordered by a competent authority, which is RERA there, RERA authority, would be highly inequitable. So the treatment of a separate class was held to be highly inequitable. Then the Supreme Court also relied upon an NCLT judgment of Natwar Agarwal. Natwar Agarwal, which is the by Mumbai bench of NCLT, which held that the underlying claim of an aggrieved party is crystallized in the form of a court order or decree that does not alter or disturb the status of the concerned party in the present case of allottees as financial creditors. Further, Section 238 of IBC contains a non-obstante clause, which means that it will prevail over other provisions, other enactments. So, IBC having overriding effect over RERA, consequently, its provisions acquire primacy and cannot be read as subordinate to RERA. So, in any case, the Supreme Court had held that this distinction made by the RP, this was artificial. It amounts to hyper classification and falls afoul of Article 14, which is the provision relating to non-discrimination, the fundamental right. Such an interpretation cannot therefore be countenanced. And therefore, the conclusion was that the appellants, who were the claimants who had also approached, home buyers who had approached RERA, they were declared by the Supreme Court as financial creditors within the meaning of Section 5(8)(f) explanation and entitled to be treated as such along with other home buyers, financial creditors, for the purposes of the resolution plan. And this resolution plan is still awaiting the final decision before the adjudicating authority. So this clarification, essentially, it is also interesting in another fashion that the resolution plan, though approved by the COC, but was still pending approval of the NCLT. During those proceeding itself, this application was filed, entertained, and then it went up till the Supreme Court, even when the main application for acceptance of resolution plan is still pending before the NCLT. So in that way also it is quite interesting. This judgment can be used for many purposes. One is about discrimination between the different financial creditors in class, where it is straightforward. Second is about approaching the adjudicating authority with any grievance against a resolution plan, even when its approval is pending, and also taking the matter further to the higher forums. So this is this way it is a bit interesting, a very short judgment, but interesting to note. Any clarity needed or any doubts relating to this issue? Any of the participants has any comment or any feedback or any something anyone wants to share?
Sir, can I talk? My name is Guneshwari. Good afternoon to you.
Yes,
yeah,
yes.
I'm dealing with several real estate cases. This, action of the RP saying that there are two different classes because they went to RERA, it's not correct in my view also.
Correct.
Because when we get the claim, some people submit the RERA orders. Some home buyers do not submit the RERA orders to us. Though they have the order, they don't give it.
Yes.
So, RERA order has to be used by us, maybe to the extent of the rate of interest. They might have allowed 10% or 15%. So, to that extent, we have to allow that in our claim admission. Otherwise, they are still home buyers. And when they are submit the claim, it is our duty to accept the claim. We cannot say that you are a different class of buyers.
Correct.
The law does not distinguish, and Supreme Court has rightly pointed out.
Yes.
This is how I see. But anyway, thank you for bringing this to our notice. I did not know about this order, but Supreme Court order is very good actually. It's a eye-opener that some of the RPs may think like this.
Yeah, so you can make a note of this. It's the mention the
Yeah, I
slide.
have noted down, yes.
Yes, and in fact, even I was not aware about this order till like 3-4 days ago when ICSI itself shared this one that I have to share it with you. So
Okay,
it's a
okay.
very recent order, 6th
Yeah,
October only.
it's quite
But it's
informative, yes.
quite informative, and I mean, it is this issue. The issue which is being decided is about discriminatory treatment amongst the financial creditors in class. But what I see is another interesting point that the resolution plan is pending approval, but then still these applications are being entertained, which usually adjudicating authorities does not entertain because they say, let us first accept the resolution plan, then you, if you feel aggrieved, you come to us. So these things happen, but this is one of the exceptional cases where, which is also good in this case, especially when resolution plan was discriminating, that this was entertained, though the appellants failed before NCLT, they also failed before NCLT, and ultimately they got justice only before the Supreme Court. So interesting case. And however, there are other issues involved. There are, I have myself not dealt with any real estate project. I have done some hydroelectric projects and related to some IT related companies and steel related projects. But I have otherwise been a part of an RP team where RP has made a distinction of different classes of financial creditors in the home buyers category itself, project wise. So that was also being pursued, and before NCLT principal bench, there are many applications. In fact, there are applications also about having separate ARs for different projects. Now, to some extent, I see a bit of advantage in that also because if having a common AR for all the projects might not lead to presentation of different views of different project stakeholders having different stakeholders who are having different concerns relating to their own projects. Because one AR, if representing all four, let us assume if there a CD has 4 projects and one year represents allottees of all the 4 projects, then perhaps he might not be able to uh, present the views of all of them because he has to only mention about the majority view. So, at so some home buyers or stakeholders who have a stake in a project which has a minority voting right might not get properly adequate representation before COC. But these are all pending issues. These are applications lying before NCLT. I hope anyone wants to share something relating to home buyers or different projects. You're welcome to.
Yes, see, project-wise ARP now, in fact, I am handling two projects of two different CARP of a particular corporate data. So
Yes.
nowadays, yes, now even with the proposed amendments and all, that's what is going to happen. Project-wise ARP is going to be ordered, or in a CD, if all the projects are under CARP, different ARs and different COC, I think that is going to be the order of the day now.
Correct.
But anyway, it is good and useful so that, the real estate projects, they get some resolution. Otherwise, all these days, the success rate has been very less.
Yes,
So it may happen. Yeah.
of
Thank
course.
you.
Thanks. So, any other views, any other comments, or any clarification needed related to this judgment, except for Bhuvneshwari ma'am?
Sir, one small doubt, sir.
Yes.
See, a resolution plan, suppose it provides for completion of the units and handing over to the home buyers, then how to ensure a similar treatment to persons who have gone before RERA and are having a decree? Decree people may not be handed over the units, I think so.
Um, See, it really depends how the resolution plan is going to provide relief to these applicants. Now, if they themselves have opted for a refund before ERA, then I don't see how they can themselves claim again about allotment of their unit. But if it is all part of resolution. So if the claimants are offered that unit again by the resolution applicant, I don't see a reason why that plan will be rejected.
So I think so. The Supreme Court order only is limited to the facts on hand, and it may be that we have also to see differently the classification by the resolution professional as against the treatment in the resolution plan. We may not mix both and confuse together.
Correct. No, in fact, the judgment is a very small one, 5-6 page judgment. So even I am not aware exactly what benefit they are offering, because what the distinction that was made is 50% more benefit to those persons who did not approach RERA. Now, what kind of benefit was that? Is it only in the claim amount? Is the resolution applicant only offering the claim amount, giving the return of money, or is it giving 50% extra unit? What is happening? Maybe there might be some vacant units. We are not aware, but it is only about subject. We are only on point of law, that there cannot be classification of financial creditors in class who are home buyers on the basis that some went to RORA, they will be treated differently in the resolution plan. This judgment is only in the context of treatment in the resolution plan. That also we should make clear. We should be very clear. This judgment is only in the context of treatment of home buyers, different home buyers in a resolution.
Sir, can I add something to this?
Yes.
This judgment is one thing, but in the practical thing, if the home buyers, if they come with RERA order, or a lot of people go to consumer court and get the order.
Correct.
However, once they submit the claim here under CIRP, they have to abide by the resolution plan.
Correct.
If they want refund of money during CIRP, then during the negotiation with the resolution applicant, they need to discuss accordingly and ask for the resolution plan, which will take care of the people who ask for refund and take care of people who want to possess the flat.
Correct. Absolutely right. Absolutely right. Any other views? Comments? So good that Adinarayanji had pointed out. So we are just clarifying. This is only in the context of treatment of different home buyers in a resolution plan. So that should not be discriminatory. RP's approach in accepting such a resolution plan was found to be discriminatory, and that's why, since the plan was pending approval, so I believe the Supreme Court has given that benefit to those home buyers or real estate allottees who did approach RERA, that they will also be given the same benefit in the resolution plan as given to others who did not approach RERA. Yeah. So any other any questions or any other doubts? Or should we move to the second one? Okay, so we'll move to the second case. So this was Vishal Chinani. Now, the second one is, can you see the entire screen?
Yes, sir.
Yes, the entire screen. Okay. Now, this second case is also.
My video is stopped. Can you please start the video, please?
I'm sorry. You want to start your video? I think you have to only start it by clicking on something on video button. I can't start it for you. You have to do it yourself. Your webcam is working. Yeah.
Okay, fine. It's there.
Okay.
Thank you. Yeah.
Right.
Sorry.
So second case is another judgment of the Supreme Court. It was pronounced on 18th of October 2023. Totenpudi Salalit versus State Bank of India and others. This is about the State Bank of India. It had filed an application. This judgment is dealing with some aspects of limitation which were not dealt with earlier. A very different judgment again. So this is on limitation law. State Bank of India had filed a Section 7 application being a financial creditor against Tottenham Infrastructures Limited, which is the corporate debtor. Now, prior to bringing the action under IBC, notice under Surface Act under Section 13(2) was issued to the corporate debtor and recovery proceedings were instituted against them before the DRT. So 13(2) Surface was there. Second, DRT and original application, which is a recovery matter, was filed before DRT. Now, 3 applications were filed by the exposed lending banks. It was a big account, more than default of more than 1,400 crores was there. So 6-7 banks in a consortium were there. Now, 3 applications, 3 OAs were filed. The 2 applications were filed before DRT Hyderabad. The third application was filed before DRT Bengaluru, and 3 different recovery certificates were also issued. So decree was passed in all the OAs. I hope everybody understand OAs. These are civil suits filed before DRTs. They are called OAs, original applications. So in all, decree were passed. Upon passing the decree, a recovery certificate is issued, which in all these 3 cases, DRT had issued recovery certificates, and they were covering the claims of the lending banks. Now, 2 recovery certificates, we have to note down the dates. 2 recovery, we have to emphasize on dates. 2 recovery certificates by Hyderabad DRT were issued on 8 September 2015 and 17th October 2017. For a sum of 14 crore so-and-so, and the other was for around 1408 crore so-and-so. In OA number, this was before the DRT Bengaluru on 1930. The recovery certificate was issued on 4th of August 2017 for a sum of 5 crore 22 lakhs 21,750. Now, SBI filed a Section 7 application before the NCLT on 6th of September 2019. So kindly note the gap. 2015, 1 recovery certificate was issued. Second recovery was October 2017, and there is another one which was given in August 2017. So 1 recovery certificate in 2015 and 2 in 2017. Now, Section 7 IBC application filed on September 2019. And this Section 7 IBC application was founded on all the 3 recovery certificates. So it was a composite one mentioning about all the 3 recovery certificates. So this on basing the default on the basis of recovery certificates, in which the first respondent, who was the one of the first respondent, had substantial say. So in its order passed on 12th January 2021, the adjudicating authority admitted the application. So Section 7 application was admitted in January 2021 by the adjudicating authority. Now, what was the challenge here? Challenge was on the ground of limitation. Mainly, 2015, 1 recovery certificate was issued. NCLT application was filed in 2019. So 4 years gap. 8 September 2015 and then 6 September 2019. I hope everybody is able to follow this. It's a 4-year gap. So though there are 2 recovery certificates of 2017, but then there is 1 recovery certificate in respect of which limitation expired in 2018, September 2018. Section 7 was filed in 2019. So on these grounds, on the ground of limitation, this was challenged, and I will directly go to the court observations. What observations are made by the Supreme Court of India? So far as the present proceeding is concerned, if we proceed on the basis that the date of initial default is the starting point of limitation, then lapse of 3 years from that date would have extinguished the bank's right to initiate action under IBC. Second, even if the letter dated 29th, so there is also one more thing, a letter of 29 January 2020 was there, where the CD had said that I want to do an OTS with the bank, and it was treated to be acknowledgement of debt. Now, the application was filed in 2019, and the NCLT had considered a letter of 2020 also as an acknowledgement of debt. So I'll just read it again. Even if the said letter dated 29 January 2020 is treated to be acknowledgement of debt, the same was made after institution of proceeding under Section 7 of IBC. So in the application, thus, there could be no reference to such acknowledgement. In absence of amendment of pleadings, the appellate tribunal could not have taken such purported acknowledgement of debt for the purpose of extending the limitation period. So Supreme Court made it clear that this letter dated 29 January 2020, which was relied upon by the banks, since it was not existing at the time of filing the application, it could not extend the limitation. Second, it also clarified that an acknowledgement of debt, if it was made after the limitation period is expired will not increase the period of limitation. It will not extend the period of limitation. Then next, para 12, Supreme Court holds one factor which has come to our notice in course of hearing is that one of the recovery certificate was issued on 8 September 2015. We have already held that the letter dated 29 January 2020 cannot by itself revive the debt, though it could create an independent cause of action. So Supreme Court did not say that the letter is not significant, but it said that it cannot revive the debt, though it can create an independent cause of action. A question that arises now is as to whether the debts in connection with the recovery certificate issued in the year 2015 could form subject matter of an application under Section 7 of IBC filed on 6th September 2019. So highlighting the 4-year gap, can it be part of, can it be treated as part of the, can it be treated as filed within limitation? Now, the Supreme Court drew reference to one of its earlier judgment of Kotak Mahindra Bank versus A. Balakrishnan, a 2022 Supreme Court judgment, and in which it was held that the CIRP could be brought within 3 years from the date of issue of recovery certificates. So an earlier judgment already holding that from 3 years of issuance of recovery certificate, CIRP can be brought in. So then referring to this observation, relying upon this, the Supreme Court holds that we are otherwise not satisfied with the argument of appellant about maintainability of application, out of which this appeal arises on the ground of application being barred under limitation. Now, the application with respect to two recovery certificates issued in the year 2017 is maintainable. So, Supreme Court clarified, as far as two recovery certificates are concerned of 2017, since application was filed in 2019, which is within 3 years, so it is not barred by limitation. Now, this is now an interesting order is passed, an innovative order. In the event the appellate tribunal is of opinion that the CIRP could not lie so far as the recovery certificate of 2015 is concerned, as the decree would be still alive, the claim based on the recovery certificate could be segregated from the composite claim, and the committee of creditors shall, in that event, treat the sum reflected in the said recovery certificate as part of the claims made in pursuance of public announcement. So Supreme Court clarifies, though NCLT and NCLAT had not given any reasoning, but had only stated that the application is maintainable, is not barred by limitation on the ground of a 2020 acknowledgement, which we have read, 29 January 2020 acknowledgement. If you see in 29 January 2020, but Supreme Court clarifies those observations are wrong, that 29 January 2020 acknowledgement will not extend the period of limitation, since this acknowledgement was after the expiry of the period of limitation. This is in relation to the 2015 recovery certificate. However, in relation to 2017 recovery certificates, the application was within limitation, within 3 years. So Supreme Court says that for the purpose of admission of Section 7 application, the recovery certificate of 2015 will not be considered. But even otherwise, since the application was maintainable because of the other two recovery certificates, so the admission was correctly upheld. But then another direction was issued that the part of 2015 recovery certificate should be treated as a claim before the IRP under Regulation 13 of the CRP regulations. These directions, they issued an exercise of their Article 142 jurisdiction, which is to do justice and equity. So, a bit interesting. I hope everybody was able to understand this. Anyone who has any doubt in this case? I hope I was clear about in this. It's a bit complex also for those at least who are not from a legal background. Any doubts in this? So recovery certificates, 2015, 2017. In respect of 2015 recovery certificate, Supreme Court clarified and even rejects the NCLT and NCLAT's observation that the debt was not time barred on the basis of acknowledgement of debts. But since the application was complete and in limitation in respect of two recovery certificates of 2017, the Supreme Court upheld the admission of application but treated the other 2015 recovery certificate claim to be part of claim before IRP. Any doubts, any comments, or any observations in relation to this? Any questions?
Sir, Raghuram here.
Anji. Ji, sir.
See, now the claim can be submitted before IRP for in respect of the 2015 certificate you are saying. Is that correct? Hello. Sir, I'm audible.
I think he's got disconnected.
Hello.
By mistake, next month. Correct pass the complete करावे नहीं सर question में transfer करें एक वीडियो टीचर में तो करा
I'm sorry, Raghuramji, you were saying something. I got disconnected.
What I was asking is if if the application can be admitted based on the recovery certificates for which limitation is available. That's what you said.
Yes. Yes.
And in respect of the recovery certificate where the limitation has expired, a claim can be submitted before the IRP.
Yes, that's true. That is true because recovery certificate will, since the bank has a recovery certificate, especially we'll take this example 2015 recovery certificate limitation barred by limitation because NCLT application cannot be filed. But as far as claim is concerned, we cannot say that the it is barred by limitation because bank had initiated recovery proceedings before the DRT. So, which means it must have been within limitation when it had filed recovery proceeding before DRT. That is why it had got a recovery certificate. So, in such cases, that claim will be admissible before the IRP.
So, IRP is bound to admit it?
Of course, because it's a court decree and IRP will only see the aspect of limitation while admitting or rejecting claim or not admitting claims when the claimant has not initiated any recovery action within limitation. Here he has a decree in the form of a recovery certificate, which means he initiated action, the bank initiated action within time before a court of law.
Okay.
Yeah.
Okay, sir. Thank you.
So any other doubts or anything related to this case? Let me share the PPT. Can you see the screen?
Yes, sir.
Yes.
Can you see the slideshow or it's a window?
No, only window. The slideshow not there.
Just give me a second. Just give me a second. Can you see the screen now?
Yes, sir.
Yes.
Right. Yeah. Any other comments or questions related to this case? So, just a recap. There are two issues which are dealt with. There is one more issue. I've not dealt with it just in the slide. There was another argument raised before Supreme Court that doctrine of election does not allow the bank to take action under IBC when it had initiated SARFAESI measures. So, in respect of that, there is a settled law in the case of there is one case of Transcore of 2000. I think it was during SARFAESI when SARFAESI was initially challenged. So, in that case, Supreme Court had held that just because bank has exercised recovery proceedings under DRT by filing a civil suit in the form of an OA, it is not barred to initiate SARFAESI action, and doctrine of election will not be applicable. So, supporting that, the Supreme Court in this case also has held that Section 7 can very well be filed even if bank has initiated SARFAESI actions. It is also a settled law. In many cases, it has been held. Now, should we start with the third case? So,
Sir, one doubt, sir.
yes.
The direction the Supreme Court has issued in exercise of Article 142 jurisdiction. So this direction is limited to directing the RP to accept a time-barred claim.
Yeah, so it is not a time barred claim. It is time barred only for the purpose of a Section 7 application.
Section 7, I can understand, but
Yeah.
asking the Committee of Creditors to treat it as a claim made in pursuance of a public announcement, it
Yes.
appears that Supreme Court has indirectly directed or directly directed to exercise of special powers, which normal courts IRP won't have. That means IRP will reject a claim which is prima facie time barred.
So again, I'm saying it is not time barred because recovery certificate was issued in 2015, but the bank had initiated recovery proceedings much before that. Recovery certificate came because the bank went to court. Please appreciate this. DRT has issued recovery certificate because our SBI had appeared before DRT. It had filed a case before DRT. It is not as if without going to courts, it had got a recovery certificate, which means it must be within limitation.
I have another opinion, sir.
Ji.
The recovery certificate, the further course of action would be to enforce.
Correct.
So, having not taken any enforcement action during the 3 years, maybe I don't think so. I am not that much well versed, but recovery certificates enforcement, maybe I don't think so. How many years?
Sir, I will clarify what exactly is the procedure before DRT. DRT OA is filed by the bank just like a regular civil suit, but it's a special tribunal having jurisdiction over 20 lakhs. We all know that. When a recovery certificate is issued, which is like a civil court degree,
Yes, sir.
Thereafter, it is the duty of recovery officer, not the duty of bank. It is the duty of recovery officer, which was the RO DRT, to execute that recovery certificate. So,
Okay.
of course, bank has to appear before RO proceedings, recovery proceedings, but it becomes the duty of the recovery officer. So, even otherwise, I mean, even if the bank does not appear before DRT in the recovery proceedings, recovery officer is very much within. It is his duty to enforce a recovery certificate.
Understood, sir.
Right.
And
Second, again, I'm pointing out just for clarification, a recovery certificate is issued only after satisfaction of DRT that the OA filed before it is correct, including on the aspect of limitation. Now, I assume 2015, if the recovery certificate was issued, the default must have occurred somewhere in 2012, 11, maybe earlier than that. But yeah, had the cause of action for filing OA, if there was a time bar, if it was a time barred OA, then recovery certificate would not have been issued. So that
yes,
is
sir. So now I understood, sir. Maybe that three recovery certificates were part of the same application, the same company petition, and since one recovery certificate was time barred, the whole company petition was liable to be rejected. That means to say they had to file another company petition. That's why Supreme Court issued directions under Article
Yeah, see,
145.
there was irregularity in the application, I would say that, because there are two other recovery certificates which were not time barred. And if we see the amounts of these recovery certificates, all of them are more than 1 CR, 1 crore.
Huge, yes, sir.
So, which means default, even if we take any of the 2017 recovery certificates, the default would have been more than 1 crore.
Yes,
So maybe in other cases where recovery certificate amount is lesser than 1 crore, maybe we would have a different situation. But here it is very crystal clear that any one of the recovery certificate would have triggered the 1 CR default.
yes, sir. Thank you.
Any other questions or comments? Okay, so we'll now start with the third case. Now these are only two Supreme Court judgments that we are going to deal. Now we'll do with some mix of NCLT and NCLAT. Now this one is an NCLT Kolkata bench passed on 20th of October 2023. Manavta Trade Link Private Limited versus Manikaran Wincom Private Limited. Facts are that the Section 7 application was filed by Manavta Trade Link Private Limited, who is the assignee, and the amount claimed to be in default is rupees 2 crore 72 lakhs 4,493 as on 25th December 2022. Now, the loan was sanctioned as an unsecured loan of rupees 1 crore 40 lakhs by the assigner, that is SSA Hire Purchase Private Limited, vide a loan agreement duty accepted and agreed to by the corporate debtor. So, loan amount was 1 crore 40 lakhs. Default claim by the assignee, who is the Section 7 applicant, is 2 crore 72 lakhs. The assigner had disbursed 1 crore 40 lakhs on 1st April 2016, and the said disbursement was confirmed by the corporate debtor. The corporate debtor had also issued the receipt and promissory notes. It was the case of the applicant. Anyone wants to say something? I'm having some disturbance with somebody's mic. Or has anyone turned the mic on? Okay. So the assigner had disbursed 1 crore 40 lakhs on 1st April 2016, and the said disbursement was confirmed by the corporate debtor. Now, the corporate debtor had also issued the receipt and promissory notes thereof. It was the case of the applicant that the assigner had intimated the corporate debtor that the debt has been assigned in favor of Manavta Trade Limited. So the applicant has himself alleged in the application that intimation was given to the corporate debtor that the debt stood assigned to the applicant by Manavta Trade Limited, to Manavta Trade Limited. And the applicant, the assignee, had also requested the corporate debtor to make payment of debt along with interest directly in favor of assignee, while letter dated 2nd May 2020. So this information was given to corporate debtor and while letter dated 2nd May 2022. And the application was filed somewhere in December 2022. The corporate debtor, via a letter dated 15th July 2022, acknowledged the debt and sought for extension of time in repayment of loan. However, the corporate debtor failed to make the payment. So, corporate debtor acknowledged the debt, sought time for extension of time for repayment of loan, but committed a default. The respondent corporate debtor, however, contended that the assignment was unregistered. So, legality of assignment itself was challenged before the NCLT Kolkata bench, that the assignment was unregistered and the applicant had no locus standi to file the application. Because of the contention was that since the assignment was unregistered, so it was not a legal binding document. It cannot be put forward before a court of law or a tribunal to for the applicant to prove that he was a financial creditor. It was further contended that once it is held that the assignment is invalid, the debt becomes time barred and the application will not legally survive. So now, what are the findings of the NCLT Kolkata bench here? First, it holds that registration of assignment is not mandatory. So assignment of debt being a movable property, not a immovable property, so it need not be registered under the Registration Act. Second, even otherwise, the corporate debtor never disputed the assignment till date. In fact, the corporate debtor was in correspondence with the applicant seeking time to repay the loan with interest, and therefore at this stage the respondent cannot question the validity of assignment. So one is about validity of assignment, whether registration is required or not. So assignment of a loan need not require any registration. Second, by its own conduct, estoppel is on corporate debtor by when it had itself communicated, accepted that it has to pay it to the assignee. Now later he cannot say, can challenge the assignment itself. So the adjudicating authority, it relied upon the decision in CFM Asset Reconstruction Private Limited versus Nikhil Footwears. Another judgment where there are certain observations that are made by the coordinate bench defining the financial creditor, and where financial creditor means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. So further, it holds NCLT Kolkata that we are of the considered view that the assignment of debt essentially being a transaction between creditor and the assignee, and assignment being recognized by the court as a valid mode of transfer of rights across the ambit of Section 5, Clause 7 of the Code. Therefore, the entity who received the said assignment of debt falls within the fold of financial creditor. Further, we are persuaded by the decision of NCLT in Lalan Kumar Singh versus Phoenix CRC, wherein the NCLT, while reiterating the objects of the code, observed that in the present case, we find that the appellant has sought declaration that the assignment made by the HSBC to Phoenix as illegal, which can be raised only in a civil suit. The appellant is trying to convert the proceeding under the IBC as civil proceedings akin to a trial, which is not the legislative intent. Therefore, considering the exemption provided under Section 5, Clause 1A of the SURFACE Act, we are not inclined to accept the contention that the assignment agreement being unregistered is not legally enforceable. We also observed that in a summary proceeding like the IBC proceeding, it is out of ambit of adjudicating authority to go into the details as regard the requirement or exemption of registration of the assignment agreement and other related issues concerning the legality and issue of privity of parties to the assignment agreement dated 18th January 2021. Therefore, in this background, the assignment cannot be challenged in the petition under Section 7. So they are saying another aspect that NCLT seems to have no jurisdiction to adjudicate whether an assignment is valid or not. For that, the CD had to go to a civil court seeking a declaration that the assignment is null and void. So this issue cannot be decided by the NCLT. It is explicitly and evidently discernible that there is a default of financial debt. The debt is in excess of threshold limit. Debt is not time barred in view of acknowledgement of debt by the later dated 15 July 2022. An application under section of 7 of IBC is complete in all respects. Therefore, the admission order was passed by the NCLT Kolkata bench. Yeah. So a very short case, and it's about assignment, legality of assignment. Can it be challenged before NCLT? NCLT says no. If at all this assignment had to be challenged, the corporate debtor had to file a civil suit seeking a declaration before a civil court. Second, even otherwise, an assignment need not be registered. And before that, corporate debtor itself, by its own conduct, by its own communication to the FC applicant, had acknowledged the assignment also. Acknowledged the assignment, sought time for extension to pay the loan amount, and then, of course, the assignment deed need not be registered. It need not be registered. So that's why. So on merits also, it has actually gone into accept the assignment deed. Any questions, doubts? Yes, Adi Narayanji, you wanted to say something?
Yeah, sir. Sir, one a small issue here. Maybe the NCLT was of the opinion that since the original debt is debt and default are established and it is not time barred, it need not to go into the validity of the assignment agreement. I think that is the point here. And even otherwise also I was wondering, each and everybody can be an assignee. Maybe there is some act which regulates the assignment of agreements.
Assignment is otherwise a part of Contract Act only. So under Contract Act itself, it can be assigned to anyone.
Anyone.
It can be assigned to anyone. I don't see any. The Contract Act provisions will be applicable, perhaps nothing else. If it is barred by any of the provisions of Contract Act, let's say if the assignment per se is against public policy or any other statutory provision, only then it can be challenged. Otherwise, see, all banks, if they are not able to recover loans, they assign their debts to all these asset recovery companies, ARCs and all. So it is not as if debts can be assigned to only an ARC. It can be assigned to any other company also. I
Okay.
think there might be some limits on this because that is why specifically ARCs are there. But assignment per se, I think there is no law because here we are only talking about financial debts. But even otherwise, in other cases also, we see assignments also happening. In one of the cases, since assignment is only related to money, so it need not be registered before a sub-registrar office.
Yes, sir. Understood. Thank you.
Any other comments or doubts?
I think this is a decided case by Edelweiss also in Edelweiss and reconstruction company against I think one of the cases already this particular subject matter was decided that assignment is legal and whether it is stamped subsequently, it doesn't matter.
Whether it's stamped?
Yeah, stamped, the
Yes.
stamp subsequently.
Yes. So no, if it is a case of stamp, I know. Are you talking about NCLT only?
Yeah, NCLT only.
NCLT. Yeah. So when it comes to stamping, there is a window bracket even after execution. I think it has to be stamped within a particular.
You pay the fine and compound it and
No,
pay.
no. That is different. What you're talking about is impounding and then going for before collector of stamps. I'm saying even after execution, the collector of stamps has authorized the parties to, for instance, let us say you and me enter into an agreement today. We may not have a stamp paper today, but I can purchase a stamp paper or you can purchase a stamp paper within 2-4 days, 5 days. and that would be a valid document even thereafter.
Exactly. That is what. Yeah,
Correct.
exactly. This is, I mean,
So,
subsequent,
yeah.
it's allowed.
Yes. So that document will not be impounded, but only when for the purpose of presenting such document before a court of law in evidence. Then
Yes.
it cannot be read if it is not properly stamped, and then it will
Right.
be impounded, and then the collector of stamps will impose, which usually they don't. They only say you pay the stamp duty. That's it.
Yeah, exactly. Yes.
That's
yes.
correct. Correct. It's a settled law that it can be done. I mean, but yes, it cannot be read till the stamp duty is not paid.
Yes.
Even that document remains impounded. I don't know about the NCLT judgment, but yes, civil position is clear. Civil law judgments.
No, there is a NCLT judgment also on very matter.
Yeah, but here this issue is not about stamping. Here it is about whether it was required to be
Assignment.
registered or not.
No, I'm talking about assignment. Sir.
Yes.
Yes.
Yes. Yeah, assignment. But here it is about registration. Registration of assignment.
Okay.
Yes. Any other comments or issues? Okay. So should we deal with the fourth case then?
Yeah.
Okay. After the fourth case, I think we can have a break of 10 minutes. Now this one is NCLT Hyderabad. I hope everyone can see the screen.
Yes, sir.
Yes. Thank you. So NCLT Hyderabad, SMC Infrastructures versus State Bank of India. Now, brief facts are that an application was filed by SMC Infrastructure, who is the successful resolution applicant under Section 65 of the Code, read with Rule 11 of NCLT rules, seeking direction to the State Bank of India to release the proceeds of, so this is an insurance matter, to release the proceeds of 62 lakhs so and so received by it pursuant to surrender of insurance policy. So and so, which is a Flexi Smart Plus Gold Cover Point Plan series. It was held in cash credit account number so and so of the respondent. So the application was filed by the successful resolution applicant against SBI that they should release the amount received in insurance to the successful RA. Now, the corporate debtor here had procured an insurance policy with SBI Life Flexi Smart Plus bearing policy number so and so dated 14th October 2015 for its employee, namely Mr. Raja Shekhar, under employer and employee scheme from SBI Life Insurance Company Limited, with a term of 5 years with effect from 8th October 2015. And Mr. K.V. Radhasekhar, MD of CD, was nominated as the life assured under the said policy. The NCLT approved the resolution plan with order dated 30th March 2021 in IA number so and so. In accordance with the terms of the approved resolution plan, the management of CD had changed and the applicant was in control of the affairs of the corporate debtor. So the successful RO had already taken over the management of the CD pursuant to the acceptance of the resolution plan. Then the applicants had requested the respondent is SBI in this case, for release of the amount received in lieu of the policy commencing from 5th January 2022 via various emails, but the respondent neither transferred the same nor responded to the emails. It was contended by the applicant that the respondent SBI had no right to withhold the payment received by it on account of the aforesaid insurance policy. The contentions, there were 5 contentions made by the State Bank of India, SBI. First, the details regarding insurance amount have not been mentioned in the information memorandum. So first contention was IM does not specify the insurance amount, and the amount due from the company towards the surrender value of the policy was not included in the assets of the company, and the amount was not taken into consideration by the RP while valuing the corporate debtor in the CIRP process. Second contention was the RP failed to collect and monitor the policy. As a result, it did not reflect in the assets of the CP. Yeah. So, I would request you to mute yourself, please. Yeah. So The RP failed to collect and monitor the policy. As a result, it did not reflect in the assets of the CD, and the applicant number one failed to collect and monitor. So applicant number one bid for the company without taking the amount into consideration. So SBI's second contention was the resolution plan came forward without considering the insurance amount. The COC also approved the plan without having any knowledge about this amount. Surrender of policy and payments due occurred prior to approval of resolution plan. So policy was surrendered and payments due also occurred prior to approval of the resolution plan. Therefore, the respondent being a secure creditor is entitled to the amount. Policy proceeds, third contention, policy proceeds accrued post approval of the resolution plan is ill-conceived. And that policy was surrendered in 2018 and the lock-in period ended on 8th October 2020. So policy was surrendered 2018, lock-in period ended on 8th October 2020, and the amount became due much earlier to the approval of the plan and has nothing to do with the plan. And as such, the applicant is not entitled to the proceeds of 62 lakhs, so which is the insurance amount. The respondent placed reliance on the provisions under section 68, 69, 70, 71, and 72 of the Indian Contract Act, which deal with unjust enrichment, which can be defined as a benefit received at the expense of another, which is neither legal nor can be comprehended as a gift against which the beneficiary has to pay reimbursement or restitution. Thus, in the instant matter, classifying the policy as a receivable debt rightfully and legally belongs to secured creditors of CD and not the applicants. So ultimately, the nutshell of the argument is that IM did not mention the insurance amount. Second, resolution plan does not mention the amount will be given back to it, since nobody was aware about this insurance. Even the RP did not take control of the policy or collected or monitor the policy. And since whenever the amount under the insurance went to the SBI, it is being a secured creditor has a right to withhold this amount. Now, rejoinder submissions were made in this, and it was averred that corporate debtor was taken over by a successful RA going concern, which included both present assets as well as those that accrue to the corporate debtor at any point of time subsequently. There cannot thus be exclusions in relation to any assets on any ground whatsoever unless specifically dealt in the approved resolution plan. So, to this, the answer by the applicant was that being a successful resolution applicant and having taken over the company as a going concern, it had taken control of all the assets. It had taken over all the assets, including those which were not even comprehended at that time. So, what do you think? What will be the verdict in such a case? Any guesses? I hope everybody understood the case. Some insurance amount received on behalf of the CD, but it was not mentioned in the IM, it was not mentioned in the resolution plan, and since it was an SBI insurance, so the secured creditor SBI received that amount. When the resolution applicant approached SBI to return this money, SBI rejected it, saying, I'm sorry, I cannot give this money to you since it was never part of the resolution plan. It was not considered in the CRP process. RP never took control of this insurance amount. Now, the RA states that since it has taken control of the company as a going concern as part of resolution, it is entitled to this amount. Any guesses? What should be the verdict?
The insurance claim received before the resolution plan is approved.
Right.
So, I mean, it goes into the kitty, right?
Kitty means
The creditors, I mean, for the distribution of the creditors.
which means you are with SBI.
Yes.
Okay. Any other views?
No, it was for the benefit of someone, and the secured creditor cannot have this. this should go with the company because it has been taken over as a going concern and it was for the benefit of some other persons. So it should go with that only.
Any other views? We have a 1:1. Any third? We need a third member of Adjudicator Authority.
It will go to the bank only, sir.
Should go to the bank.
Bank only.
2:1. Any other views? Okay, let's see. So what was posed? What is the question? Whether the respondent's act of withholding of amount, the respondent here is SBI, under the policy is received after the date of approval of resolution plan is correct and as per law. According to resolution plan, there cannot be any exclusions in relation to any assets of CD. That is the finding. With regard to the insurance policy, namely SBI Life Flexi Smart Plus, bearing policy number so and so for the MD of CD under employer and employee scheme, the benefits of policy will come back to the corporate debtor only. So the minority in our participant is the correct decision. As per chapter 7 of resolution plan, it is stated that any securities held with such creditors in form of security deposits, margin monies. So they've referred to a provision made in resolution plan itself. Of course, we did not know this beforehand. Any security held with such creditors in form of security deposits, margin monies, term deposit repeats or receipts or retention money shall not be adjusted against any outstandings of the CD. It will not be adjusted against any outstanding of CD and shall be directed to be returned, refunded to the CD, and the same shall be released upon fulfillment of the RA of all its obligations under the resolution plan. Though it is only talking about securities, I don't know whether insurance claim will be called a security or not. But let's see, though this insurance policy per se is not covered under this clause, as neither, they are saying this, though this insurance policy per se is not covered under this clause, as neither financial creditors nor RP were having knowledge of it, but the intent of this clause is very clear, that any money with the third parties like creditors in the form of security deposits, margin money, term deposit receipts, or retention money will be released to the CD. Further, this amount can be considered as retention money also, as this was retained by insurance company on account of lock-in period clause in the insurance policy. It is very clear that the amount payable by the insurance company belongs to the CD, and the corporate debtor, which is under the new management, is entitled for the same. Further, in terms of the approved resolution plan, there is no such clause which provides for payments of receivables to the creditors. So, even there was no clause relating to, if had there been a clause that any further receivables will be paid to the creditors, then perhaps then SBI would have succeeded. But on the basis of facts and legal position, as stated above, the respondent SBI is not entitled to the said amount. So this is the sum and conclusion, that in such kinds of, and this is a helpful judgment, will be helpful in other cases also, where we don't know about any amount, and in fact in large number of cases, in majority of cases, IRPs, RPs don't know many of the receivables. They are not even aware about certain amounts which are, because we all know there is very less support, or in fact nil support from the ex-management. So in such cases, anything new coming up for the CD, it will have to go to the successful RA. It is a good precedent. It can be quoted while making a particular decision, even when you are a part of a monitoring agency, so that this money has to go to the RA and not the creditors. Because if it goes into the kitty, then who will decide how much share would be? So, of course, it is always better that the resolution plan has proper clarity on these issues. But where there it is not mentioned, perhaps this interpretation is, the amount has to go back to the beneficiary, which is the company.
It has to go to the company, right? Correct.
To the company. The company.
Company.
Successful RA becomes the company.
Yeah.
Any other any comments on this fourth judgment, or any of the four judgments, whatever four different issues we have discussed? Quite interesting issues, all four of them. Any, or then we can take a break. We can take a break for 10-15 minutes, whatever you say. We are at 4 o'clock right now. So we can take a break of 10 minutes and then we'll come back. All right.
Okay.
We'll see you
Okay.
at 4:10.
Yeah.
At 4:10. Yes, welcome back. I hope all participants are here. Okay.
Yes, yes.
All right. We'll start with the next slide. Just a second. So we have done the SMC infrastructure. We have done. This is the NCLT Hyderabad verdict here.
Yeah.
And now the fifth judgment is this. This is Radha Syria Properties versus Jay Narayan Gupta, liquidator. An IA was filed, number 975 of 2023, before the NCLT in company petition. It's related to the fee of liquidator, and especially in cases of compromise and arrangement matters. So an application was filed under section 65C of the code by the applicant against Jay Narayan Gupta, who is the liquidator of the corporate debtor. Now, applicant is Radha Syria Properties Private Limited against the liquidator, seeking direction to the liquidator to refund an amount of 23,88,280 to the applicant. Now, there was no resolution plan in this matter, and pursuant to the NCLT had passed an order of liquidation via an order dated 24th January 2022, and the respondent was appointed as the liquidator. The applicant was proponent of a composite scheme of compromise and arrangement between Radha Syria Properties Private Limited and the creditors of Barkal Enterprise, which is the CD, which went into liquidation. The applicant came to know that the liquidation process was started against the corporate debtor. On 16th February 2022, the applicant wrote a letter to the liquidator expressing its interest in submitting a scheme of compromise and arrangement, and requested to provide information, documents of inspection of assets, etc., in respect of the corporate debtor. On 15th March 2022, the applicant submitted its scheme to the liquidator, and upon request from the liquidator on 20th April, the applicant deposited an amount of 7,88,000 in the account of corporate debtor. Thereafter, April to May 2022, several communications were exchanged between the applicant and the respondent on multifarious drafts of the scheme, and subsequently on 12th May 2022, the liquidator accepted the proposed scheme of compromise and arrangement and filed an application seeking direction to direct the liquidator to conduct the meeting of raters under Regulation 2B of IBBI Liquidation Process Regulations, read with Section 230 of the Companies Act. Now, this application was pending for NCLT. In December 2022, the liquidator, on repeat occasions, insisted on depositing half of the scheme amount in the corporate debtor's bank account to the applicant. So, a NCLT, by an order dated 6th January 2023, allowed the application and directed the liquidator to hold a meeting of raters under Section 230 of the Companies Act. In February 2023, the applicant time and again made certain payments to the liquidator, total amounting to 23,88,280. On 1st March 2023, the liquidator informed the applicant that a meeting of raters was held on 17th February 2023, wherein the scheme had been rejected by the creditors. So the creditors had rejected the scheme. Now, on 21st March, the applicant wrote a letter to liquidator requesting him to forthwith refund the aggregated amount of 23,88,280. Now, the liquidator here relied upon various statutory provisions and claimed that he has rightly taken money from the applicant. In the reply affidavit, the liquidator furnished details of the liquidation cost during the period of compromise or arrangement and claimed that the overall cost incurred during the liquidation process till 17th February 2023 amounts to 24,12,172, of which the applicant has paid 23,88,000, and the applicant is liable to remit the rest amount of 23,892. as liquidation cost. Now, the issue before the NCLT, whether the liquidator is entitled to claim his fee and other cost in relation to liquidation from the applicant who is a proponent of a composite scheme of compromise and arrangement when the scheme proposed by him is rejected by the creditors. Now, relevant provisions that were relied upon, Regulation 2B, Clause 3 of IBBI Liquidation Process Regulations. It provides any cost incurred by liquidator in relation to compromise arrangement shall be borne by the corporate debtor, where such compromise arrangement is sanctioned by the tribunal under subsection 6 of section 230. So where there is a sanction, CD has to incur the cost if the compromise has been sanctioned, provided such cost shall be borne by the parties who propose compromise arrangement, where such compromise arrangement is not sanctioned by tribunal under subsection 6 of section 230. Similar now, but there is a provision under the Companies Act also, section 230, subsection 6 of Companies Act. It provides where a meeting held in persons of subsection 1, majority of persons representing 3/4 in value of creditors or class of creditors or members or class of members, as the case may be, voting in person or by proxy, agree to any compromise or arrangement, and if such compromise or arrangement is sanctioned by the tribunal by an order, the same shall be binding on the company, all the creditors or class of creditors or member or class of members, as the case may be, or in case of a company being wound up on the liquidator and the contributories of the company. So it is binding. Now, court found that a combined reading of Regulation 2B3 of IBBI Liquidation Process Regulations and Section 230 Clause 6 of the Companies Act envisages that if any cost is incurred by the liquidator in relation to compromise or arrangement sanctioned by tribunal, it shall be borne by the corporate debtor. Proviso to Rule 2B provides for bearing of cost by parties who propose compromise arrangement only when such a scheme is not sanctioned by tribunal. Now, the scheme proposed by applicant was rejected unanimously at its first motion of compromise arrangement, and this adjudicating authority did not have any scope to sanction the scheme, and therefore there is no case made out by liquidator for invoking provision of proviso to Rule 2B3. Thus, we are in view that all the costs incurred by liquidator in relation to compromise arrangement, including liquidator fee, were wrongly claimed from the applicant. So, in this case, the application has been allowed by NCLT by saying that it never had the occasion to sanction the compromise arrangement since it was rejected by creditors per se. So, in such cases, the applicant will be entitled to refund. Any questions? Any questions on this issue? Any clarity needed? Should we proceed to the next case? Just give me a second. Sorry, I got a call. So this case was only in relation to where a compromise arrangement scheme has been rejected by creditors itself. The liquidator cannot charge any money from the applicant, but so that applicant was entitled to refund from the liquidator. Now, next case is NCLAT's order Ryan Hotels versus Unrivaled Projects Private Limited by NCLT. The brief facts are that the NCLT was considering two applications, being IA number 3694 of 2023 and 1956 of 2023, in two different appeals, seeking condonation of delay in filing the appeals under Section 61 of the Code, whereby challenge was made to the orders passed by the respective adjudicating authorities. Now, Now, IA 3694, it was stated that the order was pronounced by the NCLT on 8th May 2023, but copy of the order was neither provided to the appellant nor uploaded on the website. The appellant claimed to have addressed an email on 15th May 2023 for providing a copy of the order. It is stated that the copy of the order was emailed to the appellant on 2nd June 2023. Thereafter, the appeal was e-filed on 4th of July. It is pleaded in the application that it is a trite law that a period of limitation is to be computed from the date of knowledge of the order. It is the case of the appellant that the limitation would start running from the date of knowledge of the same, that is 2nd June 2023. Hence, there is delay of only 1 day. So, however, according to the registry, the delay was of 27 days. It was also pleaded in the application that the appellate tribunal was closed for summer vacations from 2nd June till 3rd July. Hence, the period is to be excluded from computing the period of limitation. The respondent in its reply stated that the applicant had not applied for certified copy of the order. It also sent a communication to the registry on 15th May, and that was also not to obtain certified copy of the order. The period of limitation for preferring the appeal shall commence from 8th May. On the date when the order was pronounced, it was submitted that as per the notice dated 30th May 2023, issued by the Registrar of NCLT, even during the period of annual summer vacation of this tribunal from 5th June to 2nd July, the registry of the tribunal continued to function and e-filing was operational. The registry has correctly mentioned that there is delay of 27 days. Appellant having not applied for certified copy of the order, he is not entitled for any exclusion. Appeal being barred by time deserves to be rejected. So now the second application, this was first application where the continuation of delay or of 1 day was sought, but the registry had said that the delay was of 27 days in filing the appeal. The other IA of the facts are that the ground taken in the application was that the impugned order was passed on 12th January 2023, and the appellant applied certified copy of order on 6th February 2023, and a certified copy was received by the appellant on 8th February 2023. It was stated in the application that some time was taken to review the impugned order and discussing and deliberating upon filing an appeal. Appellant could provide instructions to prepare for filing the accompanying appeal on or around 20th February. Thereafter, the appellant's legal counsel commenced drafting of the appeal, and first draft was circulated on 1st March. Certified copy of order was dispatched to the appellant's counsel, which was received on 27th February. The draft appeal was thereafter internally reviewed by appellant and approved. Thereafter, the appeal was filed on 11th March. So order was pronounced on 12th January. Appeal was filed on 11th March, 2 months gap. And certified copy was applied on 6th of February, which was received on 8th February. The appellant's case was thus that the date of limitations has start from when appellant received the copy of order. Hence, there is a delay of only 1 day. So, issue before the NCLT was whether limitation for filing an appeal under Section 61 of the Code, it will commence from the date of the order or from the date when the contents of the order are known to the aggrieved party. That is the date when the copy of order is received by an aggrieved party. So, the NCLT has given categorical findings here. The present is a case where order is pronounced by the NCLT in accordance with statutory rules, namely NCLT Rules 2016. In the facts of both the above appeals, the orders were pronounced by the NCLT in presence of counsel for appellant. Thus, the knowledge of order has to be constructively communicated on the applicant, and it is not open for the appellant to state that they were not aware of the contents of the order. Limitation for filing of appeal does not commence on the date when appellant became aware of contents, but it shall commence when order was pronounced. So it is not about awareness of contents, but when it was pronounced. The orders passed by the NCLT were pronounced in open court in the presence of counsel in any view of the matter. They cannot contend that they do not have even constructive knowledge of the order. Knowledge of the order has to be actual or constructive knowledge. And when the orders are pronounced, it can very well be said that the constructive knowledge has to be imputed to the contents of order of an aggrieved party, to an aggrieved party. In event the submissions of appellant is accepted, that unless the contents are known to an aggrieved party, he cannot exercise the right of appeal, and period of limitation for filing appeal shall not commence till he is aware of the contents. It may lead to uncertainty and delay in resolution process, which are not in accordance with the scheme of IBC. IBC is a statute which provides for timely resolution, liquidation of CD. Timeline for various acts are prescribed. Supreme Court in V. Nagarajan has held that Section 61 has to be interpreted keeping in view the purpose and object of code, and Section 61 has to be put to interpretation in the above manner. We are of the view that the submission of appellant that the period of limitation shall commence for filing the appeal when aggrieved party is aware of contents of order cannot be accepted. So further, it also referred to Section 12 of the Limitation Act, which provides for exclusion of time taken for obtaining certified copy of the order. After an order is pronounced, which pronouncement is well known to the appellant, it was open for them to apply for certified copy, even if they are not aware of the contents, as per the submissions on that date. Certified copy of order could have been very well obtained by them, and time taken in preparing certified copy is required to be excluded. So it is the Scheme of Limitation Act which has been held to be applicable in IBC proceedings, and it clearly provides opportunity to any agreed party to obtain certified copy of order and file an appeal after exclusion of period obtained for obtaining certified copy of the order. So as for NCLAT, a legislative scheme takes care of all situations. So had they applied for a certified copy of the order, they would have been given more time for exclusion. Limitation for filing an appeal under 61 shall commence from the date when the order is pronounced and not from the date when aggrieved party claims to have knowledge. So that is the finding. And on the basis of this, the applications seeking condonation of delay were rejected by the NCLAT. So this is kind of a settled legal proposition that appeal has to be filed, and period for counting the days of limitation has to start from the date of pronouncement of the impugned order. And in case any exclusion is to be sought, then certified copy has to be applied by the appellant much before, and the period taken for obtaining the certified copy will be excluded. It cannot claim that since the order was not uploaded on the website, I did not have any knowledge. That will not be treated as excluded. That period will not be treated as excluded. Any questions or doubts in respect of this? Any doubts? No. Okay. Next, seventh case. This is Apoorv India versus High-Tech Gas Limited, NCLAT, New Delhi bench. Here the appeal was filed under Section 61 of the code by the appellant against order of admission, against an order where the Section 9 petition application was rejected. So an Section 9 petition filed by the OC was rejected, seeking initiation of CRP against the corporate debtor, High-Tech Gas Limited. Facts here. The CD had entered into two separate contracts, one dated 12th February 2018 and the other 8th March 2018 with the applicant Apoorv India Consultants, AICPL we will call it, in filling up two vacancies in the company, for filling up two vacancies. AICPL raised 4 invoices for services rendered. AICPL subsequently sold their business to Apoorv India Private Limited, which is the appellant, by entering into a slump sale agreement. So initially it was Apoorv India Consultants Private Limited, then it became Apoorv India Private Limited. By way of a slump sale agreement, this business was sold. claiming that all properties, assets, liabilities, rights, benefits, and interest of AICPL should transfer to them. The appellant sent a letter on 28th June 2018 demanding payment of 29 lakhs from the corporate debtor. The CD replied on 13th July 2018 denying the outstanding amount and instead raised a counterclaim of 137.53 lakhs. So appellant thereafter sent a demand notice. So here a demand was raised, to which there was a reply in the form of a counterclaim, asking for more money. Demand notice under Section 8 was issued on 30th July 2018, to which the CD sent a notice of dispute on 9th August 2018. The appellant then filed the Section 9 application before the NCLT, to which the CD filed a reply affidavit. The NCLT passed the impugned order on 16th June 2023, rejecting the Section 9 application. Assailing the order of rejection of the Section 9 application, the OC preferred the appeal. Now, contentions. It was contended by the appellant that the NCLT, after examining this slump sale agreement, had gone into the question of whether operational debt had become due and payable to the appellant. The AA had rightly that in view of slump sale agreement, the invoices raised by AICPL had become payable to the appellant. However, where the AA went wrong was in coming to the conclusion that there was a pre-existing dispute. So the issue in this case is about whether the pre-existing dispute determined by NCLT was correct or not. So there was a pre-existing dispute between the parties by relying on certain emails of CD in which the deficiency of services had been raised. The appellant asserted that the first invoice became due and payable upon the signing of the contract. The first invoice pertained to payments which had become due and payable on confirmation of assignment, signing of contracts. The amount payable against this invoice had become due and payable on the signing of contract itself, and therefore this payment cannot be linked to the quality of services delivered by the OC. So this is one of the contention raised by the appellant here. Then second was, it was contended by the respondent that NCLT, after considering all facts, had arrived at the correct finding that there was sufficient material on record which evidenced pre-existing disputes. It also contended that the OC was trying to hoodwink the existing disputes by trying to create a confusion that the executive search contract was not a composite contract by contriving artificial stages in the contract. It was also pointed out that OC had been informed by an email about gaps in the performance of the search contract, which were followed up by several other emails highlighting their performance failure in filling up the two vacancies as per the search contract, besides calling them for meetings to discuss how to find a solution to the impasse which had arisen. These emails, having been issued prior to Section 8 demand notice, clearly signify the existence of pre-existing disputes. The question before the appellate authority. Just give me a second, please. Yeah, sorry. So the question before the NCLAT here was whether there was any genuine pre-existing dispute surrounding the debt claimed by the OC to be due and payable to them by the CD. So NCLAT gave a finding that it was clear that the existence of dispute and its communication to the OC is therefore statutorily provided in Section 8. In the present case, it is an undisputed fact that the demand notice was issued and notice of dispute also was raised by CD. It is also an undisputed fact that the OC did not receive any payment from CD and therefore proceeded to file the application under Section 9. It is well settled that for pre-existing dispute to be a ground to nullify an application, the dispute raised must be truly existing at the time of filing a reply to notice of demand or at the timing of filing a Section 9 application. In the present factual matrix, the defense raised by the CD cannot be held to be moonshine, spurious, hypothetical, or illusory. The tone and tenor of the emails exchanged between the two parties clearly manifest existence of dispute which antedates Section 8 demand notice. It is well settled that in Section 9 proceeding, there is no need to enter into final adjudication with regard to existence of dispute between the parties. For such disputed operational debt, Section 9 proceeding under IBC cannot be initiated. The NCLT has therefore correctly noted the conditions laid down in Section 9 having not been fulfilled, and the application was rightly rejected. So this is reiteration of an already existing legal position. Though when the code was enacted initially, what was referred to disputes are only pending disputes before courts of law or before arbitrations. But later on, there have been many judgments, and this is also another one affirming the position that where there are actually disputes between the parties, even if there is no dispute before a court of law, even then it will be treated as an existence of dispute, especially when there were communications between the parties and the notice of demand under Section 8 was also replied back by the corporate debtor with a counterclaim. So counterclaim not in the legal sense that it was filed before a court of law, but a demand was raised by the corporate debtor itself, which was a higher demand. So if there are such kind of disputes, the NCLT will not interfere with the Section 9 will not admit a Section 9 application, and it will not interfere with such kind of disputes. It will relegate the parties to resolve the disputes by way of proper legal means. Any questions, any doubts, or any comment on this? Okay, so last case after this. Any questions? Brugesh ji, you wanted to say something?
No, sir. Yeah, good.
Okay. So, okay. Then last case, eighth case, which is Kotak Mahindra Bank versus Resolution Professional of Universal Buildtech Private Limited. A small case. This is also NCLAT, New Delhi bench, dated 23rd August 2023. What are the facts? The facts are that the appeal was filed against an order dated 5th October 2021, by which the NCLT New Delhi bench, Court 2, it had rejected an application IA number 4472 of 2021. The CIRP was initiated against the CD, that is Universal Buildwell Private Limited, on an application of FC Homebuyer by an order dated 3rd July 2018. So an old CIRP. The appellant had filed an application praying that the NCLT may recall, modify, or amend the order dated 3rd July 2018, whereby CIRP was initiated for CD as a whole, and instead order and direct that the admission and CIRP is only in respect of Universal Aura project of the corporate debtor. So what was being sought was CIRP only in respect of one of the projects of the corporate debtor. This is one of those real estate project companies only. So in 2023, I'm sorry, this is 2021, IA 2021 of 2021. This was seeking a recall of an order dated 3rd July 2018, whereby the admission order was passed against the corporate debtor. And in a way was also saying that you modify the admission order only in respect of Universal Aura project, this, and not the entire Universal Buildwell Private Limited. So the NCLT heard the application and took the view that there is no provision available to adjudicating authority for review of the order. So first, very basic view was taken that there is no power of review of the NCLT or the adjudicating authority under the IBC for review of order passed by the hence the application was rejected. The appellant before the NCLT contended that since the financial creditor home buyers were confined to only one project, hence the NCLT ought to have confined the CIRP with regard to one project only, and the NCLT has not correctly appreciated the prayers made by appellant and rejected the same. Now the findings of the NCLT here, this held that there can be no dispute to the proposition that in appropriate case, adjudicating authority could have directed, relying on the judgment of this tribunal, Flat Buyers Association versus Umang Realtek for project-wise insolvency, which is the reverse CIRP. But when the NCLT has directed initiation of insolvency against the CD on the application of the appellant, adjudicating authority could not have modified the initiation of CIRP by confining the CIRP to one project. So an attempt here to I would say minimize the scope of CIRP after 3 years, especially when the CIRP had begun in 2018, to confine it to only one project was rejected outrightly by NCLT and affirmed by NCLAT. So this is a very short order and a relevant one. Perhaps maybe a lot of discussions are also being held that project-wise CIRP, should it be allowed or not, especially in cases where admission order was passed much prior to the reverse CIRP judgment. In such cases, NCLT has not allowed it, saying it did not have a power of review, and NCLAT has also affirmed the finding of the NCLT. So this is all we have for today. Any questions or comments on this case? This was Kotak Mahindra Bank versus RP of Universal Buildtech Private Limited. Right. So we have gone through all 8 cases which we were supposed to discuss today. So all these we have done. Any questions, any doubts, or any other doubts related to IBC? Anyone has? We can discuss that. We have around 56 participants, so we can share each other's experience. Any doubt or issues anyone is having, we can be enriched by each other also. So it is not as if I'm the only one who will be the problem solution provider. Anyone else can also do that. So we have an opportunity, we can do that also. Yes. Any
Calculating this the entire 8 cases.
Sorry?
Would you be circulating this decided?
Yes. We will. I'll send you the PDF of this PPT.
Please, yes. Thank you so much.
I'll send it to ICSI people. They will forward it to you.
Okay, fine.
Yes. Anything else? So I think there are no doubts. Then we will end this session. I don't know whether anyone is there from ICSI IIP now.
Yes, sir, I'm here.
You're here. Okay. So Anjali, I think we can finish the session. I think we're done with the 8 cases.
Sure, sir, we can conclude.
Yes. All right. So thanks a lot.
Sir, you want to share your PPT?
Yes, we will. I will circulate it to you. I will mail it to you. Then you can circulate.
Okay, then I will circulate to the IPs.
Yes. All right. Thanks a lot. Thanks for the questions in hearing.
Thank you so much, sir, on behalf of all the participants in ICC IIT.
Thank you.
Thank you.
Thank you, sir.